Good afternoon. We have two cases on our oral argument docket here this afternoon. We'll take them in the order in which they were noticed. The first case is case number 24-1522, Pinellas County Transit Authority et al. Versus Williams-Jackson. Appellant's counsel, if you're ready.
Thank you, Your Honors. May it please the Court. My name is Robert Brandeis Bennett. I represent the appellant employer carrier, and I'm joined today by my co-counsel, Alyssa Pickles. The first issue that I would like to cover is that the JCC below in the subject case erred when he denied the employer carrier's major contributing cause defense.
Okay, Mr. Bennett, would you like to reserve any time for rebuttal?
Yes, please. 5 minutes.
5 minutes, thank you.
Thank you. So some brief recitation of the facts. There were two accidents. The prior accident, which has a date of accident August 24th, 2021, and the subject accident May 5th, 2022. What's interesting about this case is both cases involve the same injury mechanism, the same body parts, the same employer, and the same carrier. The first case, August 24th, 2021, was initially treated as compensable, and benefits were provided. Included in those was an MRI of the shoulder, and it showed torn rotator cuff and perhaps another tear as well, and it showed significant degeneration. What we also know about that first accident is that the claimant never fully recovered before she had the second accident. At the final hearing, defense was full 4105 and full 4009, and the judge of compensation claims found, in fact, that she had violated a number of full 4105 infractions, and per full 4009, she lost coverage for that prior claim.
But it was initially ruled as compensable, right?
Yes, sir.
But she was not entitled to benefits because of fraud.
Yes.
So is there a difference between the two? I mean, you have compensability, which is one thing, and then entitlement to benefits. So it seems to me that the JCC went back and said, because it was compensable, but ultimately benefits were not awarded for another reason, that the second accident could be included. You could look back from the second accident, and it's all workplace injury, so she gets it.
Correct. Yeah, he drew the line. Initially, what he said was, per Pearson, Proctor, Brzezinski, when you have two work accidents, you cannot apply major contributing cause. And those three cases made that decision early on. Keep in mind that the major contributing cause statute section 440.091B says if you have a pre-existing condition and you have your work accident, the work accident has to be the major contributing cause. It doesn't mention anything about limitations. It doesn't say you can't use this section for prior work injuries. It doesn't say you can only use this for non-compensable non-work injuries. Rather, your court has defined what pre-existing means for the purpose of 440.091B. And what's interesting is the judge did glom on to the early cases, which were absolutely correct. Those cases decided that you can't use a prior work injury in a major contributing cause analysis for benefits because the correct place for an employer carrier to go is to 440.42, which is what we refer to as claims for contribution, where two carriers are deciding, or more than two carriers are deciding, which one of the carriers should pay the benefits. That's why this court went to the Pearson-Proctor analysis. The problem, the challenge is you can only address facts that are in front of you. And so when
So you would say that you're not asking for us to repudiate Pearson? and
No,
Brown?
not at all. I think that's good law, but it only applies in certain situations. And that's what the Newick case illustrated, because in Newick, what happened was this claimant had 3 work injuries, but she never treated them under work comp. She paid for them herself, she used health insurance, and then she had a work accident that she did turn in. And what the district court, what your court found was that, well, wait a minute, if these prior 3 injuries were not picked up by a carrier, 440.42 is not a remedy for the Newick employer. And not a remedy because you can't use 440.424 if there is no liability from the prior carrier.
But Newick is a different case also, right? Because here we're dealing with the first injury being a compensable injury, going back to Judge Roberts' question at the outset.
It's true. And what is so, I think, elegantly done in Newick is they said, look, we realize that there are going to be situations where we need to consider whether the prior injury should be used as a pre-existing condition, whether it's for apportionment or major contributing cause. And what they determined, and the language they use is really good, what they say is while an underlying purpose of the workers' compensation law is to place on industry the burden of paying for all injuries and damages of occupational cause, that underlying purpose does not mandate that an employer carrier be required to pay for injuries that were not deemed compensable at the pertinent time due to actions of the claimant. So when you apply Newick to our case, what you see is that, like Newick, because the 2021 claim had been denied on misrep and there was no coverage.
The benefits had been denied, but it was compensable, right? So that's the wrinkle here. The benefits have been denied because of the fraud. Paulson tells us that fraud is sort of a case-specific thing. So after the second injury, we don't necessarily apply the fraud to the second injury.
Correct.
So help me through that.
Sure. So what the judge did, in our opinion, did not get correct was his view of the Carrillo case. And in the Carrillo case, what happened was the employer carrier denied the case based on misrepresentation and fraud. At the final hearing, the claimant's attorney prevailed on the misrepresentation fraud. So the case remained compensable. The JCC denied the request for attorney's fees for prevailing on winning on the misrep. The District Court of Appeals reversed that, and in defeating the affirmative defense contemplated by Section 44009 and 44105 of the misrepresentation statutes, the claimant prevailed on the issue of compensability. And then they wanted to make sure that it's clear that a compensable case can become not compensable. They went on to say, the DCA, they held that when a carrier denies a case on 44009 and 44105, and this is the quote, they place coverage of an accident and resulting injuries and thus compensability at issue. So per Carrillo, coverage equals compensability, which would mean no coverage equals no compensability. 44009 also lays out when coverage applies. And the reason why that's so important is 44009 lists what is, what isn't, and what is partially covered. And pertinent to our case, under 44009 is 44094, which says you don't get compensation and benefits if you violate 44105 in order to procure benefits. And so, consistent with Carrillo, it also says that a compensable case can then be found to be non-compensable, which makes sense, which just makes logical sense, because it's my position that what Newick does so well is it establishes responsibility. And in most cases, most work comp cases, the responsibility is clearly on industry. It's a no-fault statute. But there are things that claimants can do that will remove that case from being covered, from being compensable, one of which is 440.09 violations, which is the fraud statute. And so if you think about it, what the judge argued is that you can't use major contributing cause here because because the prior injury, the 2021 injury, was work-related. But then, based on Newick, he understood that there are some work injuries that will be considered not compensable. But he stopped at what Newick, the facts of Newick, which was the person never sought benefits, so that claim was never deemed compensable. But to follow what the judge did would result in incongruous results. Because imagine a situation like Newick. Someone did not make their claims. They never had that case deemed compensable. Then later they have an injury, and the analysis at that point is, okay, well, it was never deemed compensable, therefore an employer peer can use major contributing cause in that case. But if you were to follow the judge's logic in a case like ours, the case was deemed compensable, but then it was deemed not compensable because of fraud.
Was it deemed non-compensable, or was it deemed non-compensable in the aspect of there are no benefits available for that claim? So that PFB gets knocked out, as the JCC did here. But a subsequent injury, as I read Paulson, each case, each claim sort of stands on its own for purposes of a fraud misrepresentation type defense. And so in the case of the second injury, we don't apply the the previous fraud misrepresentation to that second injury, and that second injury can be compensable.
Right. We never made the argument that the prior misrepresentation should be applied to the May 5th, 2022 accident in the sense of you made a misrepresentation in order to procure benefits at some point in your life, and that's going to follow you to every single case. Not at all. What we argued is what happened when she committed the misrepresentation is she removed herself from a position where I'm a claimant and I get benefits and my case is covered, and per Carrillo and per Paulson is compensable. And because of the action that she took, which was to make the misrepresentation, per Carrillo and Paulson and 440.09, she removed what was a compensable case and turned it non-compensable.
Is that really what we said? We have, like Pearson says that the MCC doesn't apply when it was the prior injury was a work injury. Why isn't it just as simple as that? Why do we have to dive further into the compensability question at all? Why can't we just say, look, this prior injury was work related? That's what the statute says. Why can't we proceed and dispose of the case in that way?
Because what ends up happening is you end up resurrecting a fraud case. Because if you were not allowed to argue major contributing cause, and if the claimant didn't prove major contributing cause, then what ends up happening is in the May 5th, 22 case, now you are providing benefits that were previously denied, and that would lead to an incongruous result.
Isn't that just a potential, though? And that's where your JCC and the fact-finding, it seems, comes in. Sure, there can be an injury, a second injury, so to speak, But the JCC would have to verify that, this isn't just trying to resurrect a first injury claim in the guise of a second injury. There has to be a second injury. And here it would seem that the CSE, in your own denial of claim, conceded that there was a second injury. And so I'm not sure whether I see the potential harm of resurrecting a fraud claim. But with fact findings here, it might take us out of that basket.
Well, in this particular case, you don't have to worry about that because the JCC agreed with Dr. Butler, who saw the claimant after both accidents, who concluded that the major contributing cause of the need for her surgery and her medical benefits and disability, if any, was that prior injury.
But the point is whether or not the major contributing cause matters anyways, right? I mean, so yes, that's what was found, but the question it seems here is whether or not we're going to apply that in the context of a second injury where the first injury was also work-related. Do we apply the major contributing cause at all?
Okay, so what you're saying is if what the claimant had was an independent injury like Basinski. In Basinski, Babatovic. In Babatovic, the claimant had pre-existing degeneration and the claimant had a strain. And in that case, your court determined that there were two distinct conditions and they were unrelated. In our case, the best that the claimant can show is an exacerbation of the pre-existing work injury. And so that is distinguishable.
And that goes
Did that answer? I'm sorry.
And that goes to the findings of the JCC. Correct. Is that a challenge to the findings of the JCC? The fact findings?
There is, when you get into the other issue, which is compensability of the injury itself, gate one, if you will. But as far as major contributing cause is concerned, Newick is very clear in that even if it's a work injury, the question is, at the pertinent time, you can have a prior injury that is non-compensable, and if that prior injury is non-compensable, then you would be able to use it as a pre-existing injury if the claimant did something that made the case not compensable. So the whole idea here is major contributing cause is this statutory determination by the legislature that in every case, once a case is compensable, the determination of each and every benefit that follows, that work injury must be the major contributing cause of the need for that treatment and disability, okay? All of the changes to that have been done judicially. So there's nothing in that statute that says you can't use a prior work injury. There's nothing that says this section can only be used for pre-existing conditions that are unrelated. And so what has ended up happening is in order to preserve that defense and to preserve that burden that's on the claimant, this court has put some limitations so that it can remain consistent within the statute, that being claims for contribution. In this case, if the court were to uphold the judge's decision on whether the need for the continuing benefits, the major contributing cause, is the work injury or the pre-existing, if you didn't do that, then what would happen would be this employer carrier has no 440.424 remedy, no claim for contribution, there's no liability on the prior carrier. And then in addition to that, even though the benefits that are being sought are mainly for that prior denied misrepresentation case, they would be resurrected and the employer carrier in the May 2022 case would end up paying for benefits that were primarily due to that prior condition.
Mr. Bennett, you're deep into your rebuttal time. You may continue or save time for rebuttal.
I should save time unless you have any unanswered questions.
Thank you.
Thank you.
And maybe add 1 minute to each side.
Thank you.
Good afternoon. May it please the court, I'm Anna Catherine Stone, here on behalf of the appellee, Anita Williams Jackson. I forgot to do that, sorry, I'm shorter. Let's address the elephant in the room. Fraud and misrepresentation is sexy and dicey in the world of workers' compensation. Defense attorneys and carriers love to use fraud and misrepresentation whenever they can, and claimants attorneys, we often cringe when we hear those words. But this case should have absolutely nothing to do with fraud and misrepresentation based upon a prior order from a prior accident. Specifically, the JCC, we believe, got everything 100% correct. Not only did he apply 44009 in the sense of he did not impose the major contributing cause standard on the claimant, he also followed the letter of the law from this court's prior rulings in the cases of Pearson and all of the other cases that have
What are
come.
we supposed to make of the fact that the JCC found that Dr. Butler, from Dr. Butler's opinion, that the major contributing cause was the 2021 injury?
I think given the questions that were asked of Dr. Butler during his deposition, he was asked about major contributing cause. I think the judge was reiterating what Dr. Butler stated and in response to questions addressing major contributing cause. However, and I think one of the reasons the judge did find the ruling that he did was because Dr. Butler did go on to say that the May 5th, 2022 accident pushed her over the top to want to have surgery and need surgery, and that there's always some degree of causation due to the effects of the 2022 workplace. And going back to what has been previously argued, that there may not have been some kind of accident or injury in 2022, that's simply not part of the competent substantial evidence in this case. It clearly shows that she had an accident in 2022 and that, that a different treatment was being recommended for an aggravation or exacerbation, which the employer carrier in their brief on their initial brief on page 13 acknowledged the claimant in conducting her normal work activities had experienced an exacerbation or aggravation of her pre-existing condition as a result of the 2021 accident. I think that going back to this particular case, what they are trying to argue is that the order from the 2021 case negates compensability of the accident from 2021. Well, you can't have your accident or your injury is either happened at work or it didn't happen at work. No evidence was ever offered from a medical provider that any other pre-existing condition that she may have had was the consequence or reason for medical treatment under either the 2021 or the 2022 date of accident. And so when you look at it from that perspective, they are trying to say, well, once you have fraud and misrepresentation that has been found, then that in some way negates or takes away compensability.
Well, what's your response to Mr. Bennett's argument that this creates a scenario where this future or potentially a future employer carrier is having to pay for an injury that has been found to be prohibited, for benefits to be prohibited?
I think if the legislature had intended for there to be that limitation, they would have added that to 44009(1)(b). I think that we are left with the plain language of 44009(1)(b). It's very distinct and it's very clear that if you have a pre-existing condition that is unrelated to work, then yes, the major contributing cause argument must be applied. But when you have a pre-existing condition, and again, the only evidence in this case of any pre-existing condition was the 2021 date of accident.
So then, I mean, it sounds like then your answer is it can resurrect the benefits from the prior accident, potentially, if the facts play out that way. You could have, based on a subsequent injury, you could wind up being receiving benefits for injuries that were originally sustained in a prior case.
As the facts of this particular case, which is the only thing that this court should be allowed to look at, is that the benefits that were being sought, the need for surgery, is different from the treatment that was being recommended or offered at the time of the 2021. So you have now have a worsening of the condition, and so therefore it has its own accident, it has its own aggravation, exacerbation of a prior injury that was work-related that now results in a different form of treatment. So I do not view it as resurrecting a prior workers' compensation claim.
And the guard against resurrecting an old claim that has been barred is what, findings by the JCC that an actual new injury occurred?
I would agree that there would have to be an accident with either an exacerbation, aggravation of that pre-existing prior industrial accident to allow that there be a new claim. And I can't help but when I go back and look at this case, and I tried the underlying case, but when you go back and look at it, they knew well before they provided medical treatment for the 2022 accident that they had already denied and issued a notice of denial in the 2021 claim. They come in now saying, well, we provided treatment under the 120-day rule, and so therefore we never accepted it. But the 120-day rule, and not to go off on a tangent about that, but that's for when you don't really know what your possible defenses might be. Maybe you don't know a full, complete, accurate medical history. Maybe you don't know certain things. In this case, they had already denied the 2021, but yet they came in for the second accident. They gave her an occupational health doctor who she saw, I believe, on 2 occasions. They gave her an orthopedic specialist, which she never had in the 2021 accident.
But doesn't that seem appropriate and right? I mean, they do need to take some time to investigate whether a second injury actually occurred, and why they do it. They use the statutorily provided mechanism, the 120 days, to figure that out. I mean, that seems like that's the way we would want the system to work.
I understand that, but again, they are now coming in and hanging the hat entirely on the fraud and misrepresentation defense and order, or we didn't have the order then, but they had already issued a notice of denial completely shutting down that 2021 claim. They had to have known that major contributing cause, or the whether major contributing cause would be applied, would have been applicable. And they want to say now, well, because we denied the 2021 case, we shouldn't have to provide benefits for the 2022 case. And I just don't think that you can have it both ways with regards to that. And I would also point out that the JCC correctly went to 440.13.1D in order to define compensability, which says, and I quote, compensable means a determination by a carrier or JCC that a condition suffered by an employee results from an injury arising out of and in the course of employment. No specific defense was ever asserted in this case in the 2022 date of accident that she did not have an accident within the course and scope of employment. The JCC furthermore correctly cited the Baba Matovic, I said that wrong, versus Scan Design, which this court defined compensability as the existence and cause of an injury not the same thing as the existence and cause of need for treatment. And I think that goes back to one of your original questions, Judge Roberts, to defense counsel was, aren't they two completely distinct separate things? The idea of compensability of the accident and injury versus the provision of medical or indemnity benefits. They are not the same. So once the compensability of the initial accident had been accepted, it was accepted by law, it was acknowledged accepted in the pretrial and at the final hearing. They never disputed that the prior accident was an accident or an injury that occurred at work.
And is that what separates the Newark case? The JCC relied on Newark, but appellants say no, Newark is in their favor. What say you?
Correct. I believe that in our case, my client did go through the proper channels, did file a claim, was provided with medical treatment, and her accident was accepted as compensable. The claimant in Newark did not do any of that. So I do believe it's very distinct and it's very case specific as to that case versus our case. I also would point out that the JCC used this prior court's ruling in North River Insurance Company versus Wuling, wherein the court found 44021 refers to compensability or entitlement to benefits as separate concepts. And that's where I think the confusion comes in, or maybe not the confusion, but the argument that they are trying to argue that the order that determined fraud and misrepresentation somehow then alleviates or negates the compensability of the original accident. But that's not what those chapters or those statutes hold. They are to discontinue benefits, which are medical and indemnity benefits. It doesn't say anything about overturning or changing the complexity of whether it was an actual industrial accident. Again, I go back to what I originally said. You either had an accident at work or you didn't. There's no dispute here. She had 2 accidents at work.
And that sort of goes to the question I asked Mr. Bennett, whether this case is really just as simple as that. Was the prior injury a work injury or not? And if it is, then that resolves the issue.
And that's when I started my presentation, I said that I think that this case has no place for the fraud and misrepresentation argument to alleviate the major, or to apply the major contributing cause argument, because that has been thrown in there to create conflict basically within the facts, but the facts are the facts. This court has routinely held that if you had a compensable accident, and by compensable I mean you went through the proper channels, you had a determination either by a carrier or a court that you had a compensable accident or injury, then you should be afforded the ability to, as a claimant, to not have to prove major contributing cause for the very reason of the public policy of let's make industry continue to be responsible for accidents and injuries that happen in the workplace.
Now, your friend hangs his hat on Carrillo. What say you about Carrillo and this idea that something that's been compensable can become non-compensable?
I believe, again, Carrillo was, again, fact-specific with regards to the facts in that case. And I, again, hold firm to the fact that I don't believe that the fraud and misrepresentation that was found in the 2021 case overturned that there was a compensable accident. So, for instance, when I was roundtabling this with my colleagues, one of the first questions most of them had was, well, was the fraud and misrep to do with concealing prior accidents or injuries that would have led to the determination that the original accident wasn't compensable? No. That is not what the fraud and misrepresentation was in this case. It was...
So is there a case where the fraud and misrepresentation, because of its nature, would change the outcome here.
I still don't think when you look at the way that the legislature has written the statute, that if they had intended for a prior accident to not require the use of MCC, they would have, I believe, the legislature would have added in there, it must be an open and active workers' comp claim to afford a claimant the ability not to have to prove major contributing cause. The legislature did not do that. The legislature did not add that specific element, and neither has this court ever gone so far to add that in. I think that would be a change the legislature would need to make within 44009. There's nothing in any prior case law, nor in the statute, that says in order to afford yourself as a claimant to not have to prove major contributing cause, that prior pre-existing condition that was work-related has to still be open and active. It doesn't say that. Now, I think that's distinguishable from Newark, where you never even went through the work comp process to begin with. And I think that's different. But when you have gone through the work comp system, there's nothing in the statute that says it has to be an open and active workers' comp claim in order to afford yourself of that provision. The JCC, I also believe, correctly found that the claimant's entitlement to benefits for the 2021 accident was barred. The compensability of the 2021 and resulting injuries cannot be altered by JCC's findings of misrepresentation. And I believe that goes back to what you just asked me earlier, was can a order finding fraud and misrepresentation change the nature of the accident and injury? And again, going back to somewhat case specific, in this particular case, the finding of the fraud and misrepresentation didn't change that she had a work accident. It didn't change that the only medical evidence in this case from both Dr. Lee, who was in both dates of accident, and Dr. Butler, were that she had injuries and related to her job driving a bus, turning a very heavy wheel, and that Dr. Butler then related everything to the 2021, which was an industrial accident. You can't change the fact that there was no medical evidence to support that any pre-existing condition was unrelated to her work activities. There's simply nothing in the record to support that, and nor did they provide in their defenses when they listed pre-existing condition. They specifically listed the 2021 accident as that pre-existing condition. They did not offer medical testimony or evidence to support that the pre-existing condition was anything other than an occupational or work accident injury. The provision of benefits in the 2021 date of accident was a wholesale acceptance of compensability, and citing to this court's ruling in Churchill versus DBI. It would have been error for the JCC to find the 2021 accident was no longer compensable and apply the major contributing cause standard to the 2022 date of accident when the bar to the denial of benefits is claim specific as set out in Paulson by this court. So again, going back to all these scenarios that the employer carrier want to try and bring in to this case, you can't do that. You have to look at the facts of this particular case. What may happen down the road with another employer or another claimant and other employers, that's not what we're here about. What we're here about is the record on appeal, the evidence that was presented at the before the JCC. That's all we can look at with regards to this particular appeal. Defense in their own initial brief, pages 2 and 3, admitted their only defense raised at the final hearing for the 2021 was fraud and misrep, and had waived her entitlement to work comp benefits under the 2021 accident. There was no assertion of denial of compensability, and in fact, their own pretrial stipulation acknowledged compensability of both accident and injury. Yet they want to somehow come in and now say that because there was an order finding fraud and misrepresentation, it negates what they had previously stipulated to. And I just do not believe that the legislature nor this court's prior rulings support that finding. If the legislature intended for major contributing cause to be applied once a prior work comp case was either extinguished, as they like to call it, or cut off for any reason, then the legislature should have added this to the statute, which it did not, and would be error for this court to add in those requirements to the statute. The only thing my client had to prove at the time of trial was a contributing, precipitating, and accelerating cause of accident or injury that the judge relied upon per the Vigilati versus Kmart case. And for that reason, I believe that the judge's decision was correct. He applied the law correctly, and his order should be affirmed. Thank you.
Thank you, Ms. Stone. Mr. Bennett?
Your Honors, I would direct your attention to the Paulson case. The language in the Paulson case will help with this question about, are we talking about compensability of benefits when we're talking about the effect of misrepresentation being granted, or are we talking about compensability so that that accident is no longer compensable? Paulson, like Carrillo, says section 440.094 at least at issue here excludes coverage if the employee engaged in any of the acts described in 440.105. Excludes coverage. And then it goes on to say to require coverage to be forever barred simply because the employee had at one time committed one of the 440.105 prescribed acts, and another accident date would be unduly harsh. Now what they're talking about is coming into the third work comp case and saying 2 work comp cases ago you committed misrep, so on this third one you don't get benefits here either. That's not what we're doing. What's important about that Paulson is what they're saying is what happens when you violate 440.105 is you lose coverage, and Carrillo clearly says that
On claim, though, right? It says that it's claim specific. The bar receiving workers' comp benefits based on false, fraudulent, misleading, or incomplete statements is claim specific.
Correct. That means that if you commit fraud in accident 1, when you have accident 3, you can't say, nana nana boo boo, you committed fraud 2 or 3 claims ago, 2 or 3 accidents ago, and now you can't apply it to this accident claim. What we're saying is that we could go back to that third case and now treat that like any other non-compensable, non-work accident, because that's your responsibility. That's no longer the responsibility of industry. So Paulson and Carrillo, I think, clear that up. The other thing to remember is when you look at Newick.
And your time has expired, but I'll give you an opportunity to briefly conclude.
Okay, thank you. Yes, Newick is the case. And what you'll notice in Newick is when Newick says that the standard is employer carriers don't have to pay for cases that are no longer compensable at the pertinent time because of the actions of the claimant. It doesn't say no longer deemed compensable. It says no longer compensable, i.e., if you commit fraud in a prior case, That's a personal case, and that is subject to major contributing cause analysis. Thank you very much for your time.
Thank you, Mr. Bennett.